Hi, it's Ahaji from Ahaji Amos PLLC. We specialize in intellectual property. I'm a patent attorney. We have patent attorneys. We have folks who specialize in trademark law. I do that too. We handle oppositions, cancellations, franchising, trade secrets, and lots of other needs of inventors and small business owners. So today I'm going to be talking about provisional applications. The question that I received the most this week is, should I file a provisional application or should I file a utility application? So I always find this question really interesting because there really is not a choice. A provisional application is very different than a utility application. So when I get the question, I know that there is a misunderstanding in the potential client or the client's mind about the difference between the two. So that's where I'm going to start. A provisional application is not really a patent application at all. It's a placeholder. Provisional applications are not read by the Patent and Trademark Office. They're not examined by a patent examiner, and they never issue into patents. So you can't really compare them to a regular application that's going to be examined and hopefully one day issue into a patent. So a provisional patent application is essentially a way of holding your place in line until you're ready to invest the time and resources into a utility application or a plan application or design application, whatever non-provisional application you're going to file. Typically, an inventor will file a provisional application before he shops the application around. So the inventor may be looking for an investor to invest the money or funds needed to file the utility application, or the inventor may be wanting to find a distributor or find a partner. He may want to build a business around the invention. There are lots of different reasons why a woman would want to get a filing date for the utility application that later comes down the road. So when a provisional is filed, you're required to disclose all the information that one skilled in the art would need to make and use the application. So you still have to disclose the same information. What you don't have to do is meet all the formal requirements of a patent application, which is part of what makes drafting a regular utility application expensive. There are lots of rules and they all have to be followed or it'll be rejected. So you can spend $1,000 to $1,500 on a provisional application and then see if it's going to be worth your money to file that utility application, which is probably going to cost between $3,000 to $9,000 just for the application, and another $10,000 over the course of 3 years to argue back and forth with the USPTO about the patentability of the invention that's described. So it's really important when one is filing a provisional that they understand that if you don't replace it within 12 months, it's actually going to die. It won't be disclosed. You won't have any issues with people knowing about it or finding out about it or stealing your idea. But you'll have to start over and you won't get that filing date. So you have 12 months from the date that you file the provisional application to replace it with a regular utility application. The utility application in turn will have the filing date of the provisional application. So it gives you a year to make it, try to sell it, offer it for sale, talk about it, advertise it, look for investors, to do all those things that could create a bar both in the US and other countries to the patentability of the invention. And just as a recap for some, in the US, you must file a patent application on an invention less than 12 months after you've made a public disclosure, you've publicly used it, you've sold it, offered it for sale, or it's been described in any printed publication. So if you want to do any of those things and you're not ready to file a utility application, you definitely want to get a provisional application on file first so that when you later file your utility application, you'll get the earlier filing date and those bars won't apply to you. It's particularly important to those people who want to file outside of the country because in most countries, there is a rule called absolute novelty, which means you don't even get 12 months of being able to publicly use it, talk about it, describe it in a printed publication, or sell it. You must file an application before any of those things happen. Almost all countries will recognize the U.S. Provisional Patent System and will honor that previous filing date as long as you file those foreign applications within 12 months of the provisional filing date. So that should answer all those questions that linger in people's minds about whether or not they should file a utility or provisional. Long story short, you only file a provisional if you're not ready to file a utility. If you're ready to file a utility application, then file it. No need to waste $1,000 and $1,500 for a placeholder. Thank you so much for listening and have a great day. Please subscribe and you will get these videos weekly. Bye.